Do you ever wonder how you can get a restraining order against your neighbors, your loved one? Do you wonder how you do that if you're the petitioner? So if so, stay tuned because this is the video for you. My name is Lance Fryrear. I'm the defender of justice. Defender of justice. Defender of justice. Defender of justice. And I don't normally look like this. I look like this. And that's because I'm a defense attorney. And I'm putting out these videos to help educate the public. Now, we have a law firm in Lynnwood, Washington that's been defending people charged with crimes for more than 20 years. And we also handle restraining orders. And we're in restraining orders. What I mean is a protection order is what it's called legally. There's orders for domestic violence, protection orders for harassment, for stalking, and those type of things. And most of the information out there in the public is for the respondent, for the person who gets served with an order, who is then restrained from contacting the petitioner. Lots of restraints can be put on them. And we've had some requests to make a video from the petitioner's point of view if you're trying to get an order against somebody. So if you find this video useful, please like and please subscribe. More people will get the information they need. So I'm just going to jump right into it. How do you get a protection order against somebody? Well, the first thing you have to think about is what type of order is it? Are you going to ask for a domestic violence restraining order? And I use restraining and protection. It means the same thing. The law calls it protection order, but most people call it restraining order. So a domestic violence restraining order means that you assert you're a victim of domestic violence. And domestic violence is defined in the statute. You want to look it up. It's under RCW 26.50. We're going to put a link to the general chapter in the description. But you allege you're a victim of domestic violence and therefore you need protection. You can also ask for a different type of order called an anti-harassment restraining order. And the law about anti-harassment is located in RCW 10.14. Again, we're going to list a link in the description. And I'm filming this in February 2022. There's going to be a big change to the law July 1st, 2022. So if you're watching this video after July 1st, take a look at our channel. Hopefully I'll put out a new video about the new laws. But for now, this is the law that applies in Washington State. So for anti-harassment, that's usually a neighbor or someone following you, something like that. It could be a coworker. Basically, the respondent you're going to claim is having a course of conduct directed at you that seriously alarms, annoys, embarrasses you, causes you concern, and basically it's not for a lawful purpose, because unlawful harassment means they're bothering you not for a lawful purpose. So it's complicated, but those are the two main types of orders you might consider getting. There's also a stalking order you can try to get. There's a vulnerable adult protection order. There's a sexual assault protection order. There's an extreme risk protection order regarding firearms. But for purposes of this video, I'm covering domestic violence order or anti-harassment order, although in general, the procedures are the same. So what do? How do you go get this order? How does it work? Well, the first thing you need to think about, number one, is where do you want to file the request for the order? You have to choose a court to file it in. And typically you can file your request in the jurisdiction where you live, in the jurisdiction where the respondent lives, or potentially in the jurisdiction where the actions happened. But usually we would advise you to file the action, the request for the order, in the court system that serves the geographical area you're living in. So if you are requesting an order that is asking to toss someone out of their shared residence where they live with you, or if you're asking to control access to your shared children, then you're going to want to file the request in Superior Court typically. Superior Court is the higher level court that handles residential eviction type stuff in that case, or also child custody issues. You can file it in the district court, which is the lower level court, but they're eventually going to transfer it to the Superior Court anyway, so you might as well start in the Superior Court. It'll be simpler. If you are not asking to toss someone out of their home or to keep them from their children, then in everything except the extreme risk protection order, it's not a bad idea to file it in the district court where you live. So if you live in Lynnwood, you might file it in South District Court in Snohomish County. If you live in Seattle, you might want to file it in the King County District Court in Seattle. But what do you mean file, Lance? What are you even talking about? Well, once you determine where it is you want to request the order from, you want to either go into the courthouse and ask for a packet of materials, usually from the clerk, regarding what type of order you want to request or file a request from. That means, put something in writing and give it to the court so they can give you a case number and either issue an order or not. Things are moving more online due to COVID, and it's almost all going to be online, I think, after July. It seems is what the law says, but you could also look on the court website to see how they're doing it. But for now, we suggest you go into the court and ask for, hey, I need a domestic violence restraining order packet, or I need an anti-harassment restraining order packet, and they'll probably give that to you free of charge. And then you're going to take that packet home. You might be able to have a domestic violence advocate help you. So ask the court if it's a DV case. There may be advocates to help you fill this stuff out. But in the packet, it's going to have you list your information. You have the right to keep your address confidential in most cases. If the respondent doesn't know where you're at, you're going to list your information. And importantly, you need to list the contact information for the respondent. The respondent is the person you're seeking to restrain, okay? You're going to need to know their name. Hopefully, you're going to know their date of birth. Hopefully, you're going to know an address where they can be served with a temporary order should it be granted. So you're going to look at that packet, and in the packet, it's going to pretty much just fill in the blanks type stuff. It says, well, what is your relationship? Are you 18 or over? If it's a DV order, did you date the person? Do you have kids in common? It'll be pretty easy to figure out what to write. But then it's going to get down to questions about why it is you're asking for an order. And so that's step 2. Step 1 was figure out where to file it and get the packet. Step 2 is what do you write, right? So if you're asking for a domestic violence protection order, you're going to want to write about the acts of domestic violence. Did the respondent threaten you? Did the respondent push you or hit you or break property? What did they do that makes you a victim of domestic violence? On an anti-harassment case, have you told the respondent to quit contacting you? When is the respondent contacting you? Has the respondent threatened you? How have they made your life a nightmare? You need to write all that out in detail because that is going to be what the court mainly relies on in deciding whether to grant you an order protecting you or not. Sometimes the court will take some testimony from you, but oftentimes it's what's in the writing. So be thorough, if you can, with the reasons why you're there asking for this protection. And if you have examples like text messages or things like that, you're going to want to make very clear and legible copies and attach them to your petition so the court has that evidence. Because if the court doesn't have the evidence, they can't consider it, right? Do you have a message where the respondent has threatened you? Do you have a message where you've told the respondent to leave you alone and they keep contacting you? All of that is really important evidence the court needs to see so you can put the best case in front of the court of why you need the protection. So once you fill it all out, you're going to have to sign it. You're going to have to swear under penalty of perjury it's true. Then you're going to need to get it back to the court. So they may want you to file it in person. They may want you to file it electronically. Okay, it depends on the current process of the court. It's changing all the time. So just ask the clerks. They can't give you legal advice, but they can at least tell you what the current procedure is. So in most cases, once you file that request for an order, then the court is going to have you go to court on your own without any notice to the respondent. The respondent won't know about it unless they see their name on the computer on a court system on their own. And you're going to go to the court, and the court's going to swear you in, and then they're going to say, is everything in the declaration true? And then they might have a couple extra questions. And then the court will either grant a hearing 2 weeks in the future for a permanent order or not. So they have that option. We're going to grant you a hearing in 2 weeks for a permanent order or not. And they also have an option to grant an emergency restraint against the respondent. And so most of the time, what the court does is they look at what you filed and they say, yes, if this is true, you deserve protection. So I'm going to give you a 2-week protection order protecting you from the respondent. And then in some cases, the court is going to have law enforcement serve the respondent with the protection order, and then it's effective, or if they violate it, it's a crime. And in some cases, the court is going to make you arrange for service of the order. And there's some technicalities about why, but if the court has you serve the order, that doesn't mean you yourself. That means any person besides you who's 18 or above and not named in the order. It could be a friend, you could get a hold of a process server, but hopefully the court is going to have law enforcement serve it so you don't need to worry about it. So why is there a hearing in 2 weeks? Well, the respondent has a right to due process. So there's going to be a hearing, typically 2 weeks after you get your temporary order granted, where the respondent has to show up and then say why it is that the petitioner, in this case you, should not get an order. And oftentimes they may get an attorney, they may file a written response where you have a right to reply to it. And there's a lot of videos on my channel from the respondent's point of view. But from your point of view, you have your protection in place once the respondent is served, and now you're going to need to come back to court to try to defend your position about what you said was true. Okay, so at the full hearing, which we call the permanent order hearing, just because I say permanent, that doesn't mean forever. Okay, it's called a permanent order as opposed to the 2-week order, although the default amount of time that the court issues a permanent order for is 1 year. Okay, just a strange name. But at that hearing, if you don't show up as the petitioner, then your order is going to get dismissed and you're no longer going to have any protection. So if you've changed your mind and you don't want the order, well, one way to make sure it doesn't stay in effect is to not show up. But assuming you want the order to stay in effect, then you need to appear. And basically, the court is going to read what you wrote and then read what the respondent wrote. And then they may have some questions, and then the court will make a decision. And case could get continued. Lots of things could happen, but in the long run, they're going to swear in both parties. Some courts will take more testimony, some will not. And then the court will make a decision either granting the order or denying the order. And if the order is granted, it'll typically be for 1 year, where you could also seek to renew it later. I've got I think a video about that out there in our system. And if the court denies it, well then you don't get your protection and you have to leave. Does it cost any money? For the most part, it doesn't. There's no money that the court charges for domestic violence protection orders. They can charge a fee for the anti-harassment, but that's all going to be changing, I think, come July. So what if the other side shows up with an attorney and you want to get your own attorney? Well, you could ask for a continuance. Typically speaking, if the respondent shows up with an attorney, you may be able to ask to go get your own attorney as well. So do you need an attorney to try to get a protection order? It would be helpful if you had an attorney, because they'll put your best case forward to begin with. But the system is designed to try to make it so you can get an order quickly without getting an attorney. So we do represent petitioners, but if you don't have the finances, or you don't want to be involved with an attorney, it is set up for you to try to do it on your own. And most people are able to do it on their own. It just matters, what you feel comfortable with. So that's basically how you get a protection order in Washington State. You figure out what court to file it in. You get the paperwork to do the application from the court. You thoroughly fill out the paperwork. You go back to the court usually to get your temporary order. Somehow the respondent gets served with the order, and then you come back for the permanent order date, which is typically 2 weeks later. If somehow the respondent doesn't get served, you still need to come back to the court so you can ask your temporary order be extended so the respondent can try to be served again. And although beyond the scope of this video, if the respondent isn't being served, if they're avoiding service, you can eventually try to do service by mail or service by publication. But basically, once the respondent's served, you show up at the hearing, you argue your case, and the court makes a decision. So I hope you found that helpful. If so, please like and please subscribe. And if you need some help in this area, we do this type of work. We get contacted dozens of times a week about these type of orders. Not a lot of firms do them, but we do. So if you need some help, give us a call. We'll listen to what happened. If it makes sense, We'll set you an appointment to try to see if we can get it figured out for you. And no matter what, we will do our very best to be there for you. Thank you.